Hey everybody, welcome to the Bold Today Show. I'm your host, JD Houvener, managing partner and owner here at Bold Patents Law Firm. So this is the Bold Today Show. Unmute your speakers if you haven't already. Want to get you on this live. We're here every week, Wednesday. I am 9 a.m. to 9:30 Pacific time, noon to 12:30 on the East Coast. And we have been having fun the last week or so looking at love-related patents. If you were on last week, you saw me pull up some, at least one embarrassing one that came up on the utility side. But this week is all about graphical user interfaces. I want to take at least 10 minutes or so and kind of dive into GUIs and what's patentable, what has been done already, and kind of the history there, which is kind of fascinating. As always, I'll be looking at live questions and answering those first and foremost. But I will offer a brief disclaimer coming up here shortly. So as we do most weeks, I've got a pretty simple agenda. I've been trying to get some guests on today, and for some reason they've been getting hung up. So thank you for your like. I appreciate that. Share that with your social community. I want to have this be a thriving weekly meeting for those of you that are interested in getting more about patents. So the sequence will be: we'll talk about live Q&A. We'll talk about the free book you see behind me, Bold Ideas: The Inventor's Guide to Patents, and we'll do Alvo.com as well. Alvo questions, there are a ton. So we have a lot to get through over there. So if there are no live questions, I'm going to jump to that pretty quick after we get done talking about graphical user interfaces. So for those of you who don't know me, I'm JD Houvener. I'm a patent attorney and I own Bold Patents Law Firm. We're a small boutique. We're based out of Seattle, Washington, Seattle area, but we've got attorneys in 6 or 7 different states. And we serve inventors nationwide. Patent law is one of these beautiful areas of law that we can help inventors no matter where they are in the country. So if you're from North Dakota or Miami, Florida, wherever you're coming from, we can help you because we're not beholden to state laws. We can help inventors nationwide. All right, so bring on those questions, everybody. Flavio, good to see you. You're my number one. I appreciate you coming on. You liking the flamingos, right? Trying to brighten up the the mood around here. This is middle of winter, but why not, right? I'm thinking about vacation, having some fun, and who knows, I may even get the ukulele out today if we're having a lot of fun. So keep those questions coming, and it's great to see you guys. It's great. We have 8 people on already. It's awesome. All right, so let's get to our subject: graphical user interfaces. For those of you who may be out there with inventions, and maybe even graphical user interface inventions, I do want to make sure I put this disclaimer out. Please do not share details of your invention, right? This is not a confidential forum, as hopefully you've gathered. This is a fun place to get together and talk about the patent process, how patents work, what's eligible, what's the difference between a trademark and a patent. So hypotheticals and high-level generic questions are welcome. So if you have something you want to talk about in confidence, please do get with me directly. I am going to give you this email directly to my email inbox, and that is the phone number to send a text message. You can't call that number, sorry, but you can text it, and I will try to get back to you and set something up with you for a confidential discussion. Looks like we had a question here from Keith Andes. Keith, good to hear from you. All right, got a trademark back in 1992. I did not maintain the yearly fees. Okay. Can I still claim it? Maybe. So 1992 is a few years back. The question is, did someone else or some other company or brand pick up that mark and start using it in the stream of commerce? And are they still using it? Okay, maybe they've picked it up and they've since abandoned it, and maybe now it's available. One of the best ways to go look is to check out the Trademark Electronic Search System called TESS. If you just Google TESS, the Trademark Electronic Search System, you don't need to tell us what it is, but that would be kind of fun if you want to. We could do a little live screen share, Keith. But you go to that website and you can go pick up, kind of learn about different trademarks to see if they're available. I'll do a quick show and tell here just to show you guys what it looks like. So share screen, here we go. Okay, so it's this here, tmsearch.uspto.gov. do a basic word mark search. And, you know, let's say back in 1982, you had a hockey team, you wanted to call them, you know, the Blazing Skates. I don't know, Blazing Skates. Let's see if, there they are. I had no idea. Blazing Skates, okay, and it was abandoned back in, looks like around 2014. They filed it, and it is now dead, right? You can see whether it's live or dead. They abandoned it in 2018. All right, so this was Blazing Skates. I had no idea this was out there. Apparel, namely shirts, pants, jackets, footwear. Okay, so it was an apparel brand that was all about, you know, skates, maybe some sort of roller derby, but they let it go. They stopped paying for it, and it's now dead. So if you actually had a, you know, a company, a brand you wanted to start called Blazing Skates, you could do that, even though they had trademark rights for this for what looks to be upwards of 4 years. It's available. Okay, we want to conduct a more thorough search to see if there's anyone else using similar wording or logo for currently for live rights. Maybe there's a brand out there, you know, Blazer Skating, right? Blazer Skating, and they're also in the apparel industry, and you're interested in apparel industry, and you want to go for Blazing Skates. Well, that may be too close, and they may oppose your registration. So we want to get that research done ahead of time. So thanks for that digression there, guys. That was kind of fun. All right, let's see. And thanks for the shirt. Thanks for the comment, Flavio, on the shirt. That's awesome. Vaccines are probably patentable. You know, would you really, does it make sense to do that? That's another question. I don't want to delve too far into that. So let's see here. We got Chris Holland with a question. What's the average cost to process a patent? Beginner here. Yeah, processing a patent. There's a lot of different kinds of patents, okay? You can get a design patent, which is what we're going to talk about today with graphical user interfaces. And those are much more straightforward because design patents are just about the drawings, right? The way that it looks. That's the scope of protection that you get, you know, like a, you know, article of manufacture, right? Like the AirPod container, that shape, right? The curvature, the way that it looks, not the fact that it holds AirPods or charges or has Bluetooth capabilities, just the way that it looks. That's design patents. You can file them yourself, and pay just the filing fees and get it done for a couple $100 bucks. But is that the right way to do it? If you work with, you know, a high-end firm like ours, you might be looking at, you know, 5 or 6 or even 10 grand to do it the right way. A lot of variables, Chris. So it's hard to say. On the utility side, it's a lot more complicated because it's covering functionality. Okay, you're covering what it does, and the breadth there is greater. Okay, with the utility patent, you're getting protection on lots of different types of materials, different versions of your invention, and so you could look to be in 20, 30 grand quite easily to get a patent all the way through to issuance. I've got a great article on patent cost, and let me see if I can pull that one up here and put that in the comments here. I wrote this one myself. Yeah, this is how much does a patent cost? And it's our 2020 guide. For most first-time inventors, it's more than you want it to, okay? But I do a lot of educating in terms of really thinking about your time, right? Your time and the investment there. And I kind of speak sort of on a bit of a soapbox where the inventor really has no business, you know, learning about the law, you know, writing their own application and doing the work that an attorney who has spent their whole career doing, right? They should be inventing, and they should be, you know, making the next version of their product. So, thanks for your question, Chris. Mark, good to see you. Thanks for hopping on. Are there any maintenance fees for a trademark? Yeah, there are. You know, trademark, you've got to be able to file, I think it's every 5 to 6 years. I want to check with Matt Kolseth, our trademark attorney, but you've got to pay and actually reaffirm, you know, provide a specimen that you're still using the mark in commerce. You know, you can't just sort of squat on a name. You've got to prove to the trademark office that you're in commerce and you're, you know, telling customers who you are, and it's, you know, you're not confusing them with your mark. So I believe it's every 5 to 6 years on the trademark side. Don't quote me on that. Follow up with me via email. E. Dixon Gill MX, you're welcome, man. I appreciate it. Yeah, you're saying thanks for me doing this. Really helps people like me that are about to start the process of patenting. You got a question, can a utility patent and an industrial design, okay, let's see, help with the local economy of the city and where it's going, where it's going to be patented? Absolutely. Absolutely. So, I mean, inventions are people that are solving problems. So you've come up with a solution, in theory that no one else has, right? An improvement, a way of doing something that's functional, or even on the design side that has never been done before. Absolutely, it could help the economy. Okay, absolutely, it could help the city where you're at locally. One of the best ways to do that is by securing patent rights. As soon as you become a patent holder, you have the right to exclude anyone else in the whole country from making, using, or selling your invention. And so it's your choice as to how you exploit those rights and to who you may allow via a license to make, use, or sell, right? So you might allow, maybe even for free, your local city, county, or state to make, use, or sell that invention. If you just really want your local community to maybe have the first dibs, or to kind of go after it and have the exclusivity, you've got complete control. That's one of the main reasons why a lot of inventors go for that. So thanks for your question, E. Dixon. All right, you're welcome. You're welcome, Miriam. Good to see you. Thanks for hopping on. This is fun. We're getting a good crew together. So let's spend some time. I don't have any guests on. I did invite a few people on the last minute. So maybe next week we'll get some guests on. So this week I want to talk about graphical user interfaces and kind of what they are and whether they're patentable. So let me show you a little bit. I found a great article on it. I'll share my screen with you. And I had no idea, some of the first graphical user interfaces were put up by Xerox, the Xerox Star back in 1973. I mean, way back. The Apple Lisa in the 80s, Macintosh, and of course Windows, and eventually the iPhone, which is very famously well known for their design patent on the way that the phone itself looks. Let me try to zoom in a little bit. This will be easier to see. So a graphical user interface is really just that. It is a digital representation of the way something looks. Okay, and so on the right is sort of a perfect example of that, right? You've got this, if you've got an iPhone, this is kind of one of the first adaptations of it, where you've got these icons that make up different applications, right? Apps. And that the way that they're laid out, the way that they appear on the screen, that is patented under a design patent, right? You see that D right in front of the numbers, that designates a design patent. So they're getting protection on just the way that it looks. And infringement is found based on an ordinary observer, right? Someone who buys a phone, or ordinary observer of this type of industry, would the infringer, the infringed product, does it seem like it is substantially the same as what is covered under the design patent? That's the question, right? This very objective, simple test that a judge and jury would have to answer. So it does provide pretty decent protection, and it's what eventually caused, in the gigantic case of Apple versus Samsung, Samsung to settle with Apple based on their design patents and how similar they were. So yeah, I thought that was very fascinating. This article does focus a lot on the phones, but I want to go to Google and show you a couple examples of graphical user interfaces. And also, I love using the Google Patent search tool, so I want to show this as often as I can. I just simply typed in graphical user interface, right, as my keyword. I came down here under type and hit design patent. And then I want to look at those that are just granted, already actually have their rights granted. So you got to select design and grant. So let's look at this first one here, just to kind of dive in to understand what it is. You don't have to be the first one to come up with something as groundbreaking as Apple's iPhone, right? Here's an example of a design patent that was granted just a couple of years ago in 2018. Display screen portion having graphical user interface with transitional icon. And that's a great point, actually, because I found that it's not just a static image, okay? You can get protection for a moving image, right? Something that actually moves over time. So this first, I'll try to zoom out a little bit. You can see they've got these sort of rings, right? Sort of concentric rings, and they're moving, right? I think this could be some sort of a timer or a delay. I'm not sure what the functionality is, but remember, with design patents, we don't care. The U.S. Patent Office doesn't care what these rings actually do, right? What they signify, whether it's like a retina scan or a fingerprint. It's just what they look like. And so the orientation and the movement of these circles is protected under this design patent. So this, if you see any other symbols or icons on a smartphone like this, and it's not owned by this patent, you're likely infringing Snap Inc. Their patent here. So much like utility patents, you will see on the left side some more detail about what the history is. So you can see that this was filed in 2015, which means any inventor that came after that loses to a priority battle. I mean, if someone else had filed this similar or almost the same exact invention, you know, in September 2015, they would have lost in a priority battle to this patent. Design patents are good for 15 years after the date of issue, whereas utility patents are 20 years from the date of priority. You can see the patent documents and the prior art. So a lot of these are related or similar. This is what the patent examiner cited as, hey, I at least found these, and these are sort of similar. Or there are also references that the inventor had to come up with and tell the patent office, hey, look, I found these on my own. These are similar, but here's how mine's different. And the claim, right, the actual what the inventor owns here, what the assignee owns, Snap, is the ornamental design for a display screen portion having a graphical user interface with a transitional icon as shown and described. Okay, cool. We spent enough time on that. Hopefully people understand what the graphical user interfaces are now, and you're able to kind of appreciate that. You're welcome, everybody. Yeah, let's see. Saksham Singh, you're welcome. Nice to meet you too. And Flavio, send us your design patent number and let's see if it's published. Would you send us that? I'd love to pull up your spiral tine fork. Saksham asks, is it necessary to be a U.S. citizen to get a patent in the U.S.? And no, it is not. Anyone in the world can apply to get a U.S. patent. All right. We have done a little bit of work. I'm not going to say we've done a ton for foreign inventors that are seeking U.S. patent rights. Okay. You know, and in most cases, the patent law is different in every country. Okay, and we'll help advise you on whether you want to seek international patent protection at a later point. But one of the coolest aspects of patent law on the international stage is the Patent Cooperation Treaty, the PCT, and that has been signed by almost every country you've ever heard of, and 200 member countries have signed on to this treaty, and they sort of acknowledge that one examiner will act on behalf of the whole world. So you can identify the U.S. examiner, and all the countries, including China, I mean, all the countries out there will recognize that one search and save you a ton of money in seeking rights overseas. You're welcome. Okay, so a few minutes left. We've got 10 minutes left. I want to jump to our Alvo questions and keep the live questions coming. Oh yeah, there we go, Mark. Yes, Mark's the question. Here's another design patent number to take a look at. I think I might know which one this is. Let's take a look. So 902-308, and yeah, I'll do this real quickly because I appreciate you guys. 902-308, and then Mr. Astorja, Flavio, 907-970. Yeah, a little show and tell, right? How much would a patent search cost with a patent lawyer Edexon, I'm going to send you right to that article. All right, go read my article on that. You know, the answer is more than you thought, but once you read, you'll appreciate the value. Okay, let's pull up, and I'll share a screen here to pull up some of these design patents. I want to get some of these guys featured up here. So Mark Offseller. All right, so just I go to Google Patents just like anybody else. So Google Patents right here. It's a real simple way. Let's see if it'll pull up. And this is Mark's D902308. Okay. Oh, it's a dotting tool. Okay. So here's another example of a design patent. Mark, I figured this was yours. Looking good, my friend. This was issued, I mean, we're talking just a few months ago. You can see the applicant name, Mark Offseller, based right here locally in Everett, Washington, filed back in 2019 as a priority date. The claim is an ornamental design for a dotting tool, as shown and described. So you can see we got this sort of a featured image, but we've got 50 pages of drawings. And for the careful eye, you can see that some of these lines are in dotted line and some are in solid line. What is owned, right? What Mark has rights on is what's in solid line. And so he has got this very cool artistic tool that is adaptable to many different tip sizes and angles. And so the core part of his invention is this base structure, which I believe is hexagonal, and has these corners here with also these nubs here to prevent the tool from rolling. Very fascinating. Thank you, Mark, for letting us look at that. And then Flavio, I want to show off your fork. Let's take a look. D907970. I kind of like the ring of that. Okay, spiral tine fork. Excellent. Let's take a look at this. Oh my gosh, that is awesome. Very cool. All right, so you have got this thing issued January 19th. Congrats. That's awesome. Congrats on this. So this is just a month ago. You've got patent granted, and the ornamental design for a spiral tine fork, as shown and described. There it is, my friend. Interesting. Interesting. My mind, like, how would, do you kind of turn the fork as you go, right? To kind of get spaghetti on your fork. That would be pretty interesting. And you've also taken the approach of having a nice dotted on the handle, which allows the handle to take on any shape, right? So this handle could be all wacky, or it could be really thick or narrow, and you would have rights over that. What's protected is just this traditional fork head with a 4-prong body and the spiral tines, of course, as being sort of the most distinguishing feature. Excellent work on this. The drawings look really good. And so you can see they do all the angles, the rear and the front views, the isometric views here on the drawing. So thanks for letting us feature those design patents, Flavio. Congrats again. Swirl and twirl. All right. And thanks, Mark. Mark, go ahead and feel free to put your website, shameless promotion. You're welcome to use this platform for that. I'd love to get you guys featured here. So let's take 6 minutes or 7 minutes or so and do our Alvo dashboard. We had a lot of people come in with questions this week. We'll do a few from the patent side and a few from the trademark side. So I volunteer on this platform to answer questions. I've done 215 answers to date, and probably more than that, but it's a cool platform to just ask anonymous questions of attorneys. Let's jump to this one patent application question that comes out of Cedar Rapids, Iowa. Is my priority date worldwide the day I filed a provisional patent application, or is it the foreign filing license date? So the hypothetical situation is I filed a provisional patent application on 2/16/2021. This doesn't sound too hypothetical. Then someone abroad discloses a similar invention 2 days later through a patent filing or publication. My USPTO receipt arrives a month later saying that the foreign filing license date is 3/16. No. Foreign filing licensing has nothing to do with priority date. So the priority date will be the date it was received by the patent office. So 2/16/2021 will be your priority date. So any inventor that publishes or files an invention after you on even 2/17, I suppose even on the same day within a different hour or date or time stamp, you would win in a priority battle. All right. So that foreign filing license, all that means is it it basically will allow you to file in a foreign country and make reference back to the U.S. priority. There's almost never a reason to file sooner than that 1 month. In almost every case, you want to wait at least 12 months to kind of decide which country to enter into, if beyond the U.S. Hope that helps answer your question. Thank you for that one. All right, let's see. We'll do one from the patent infringement question bank. This comes from Larchmont, New York, and it's about patent infringement. Good day. I have made a product, and I did not realize that I was infringing on a patent, as there are numerous similar products on the market. How is it possible that there can be patents for similar-looking products? What would make them different? The product in question is a compression hood for a horse. You're limited in the shape and look of the mask due to the conformation of the horse's head. The only difference I can see between the 3 or 4 similar products is a slight style difference, and then the different fabrics being used. The patent which I have been made aware of, as one being one I'm infringing on, has a status of ceased, and it is anticipated expiration date is last month. What would the implications be if I continue to make my product? Well, patent holder has the complete control. I mentioned this earlier on who they go after in terms of who may be infringing, and so it could probably be that they may have other infringers or copycats. They just don't think it's worth their time going after them. For some reason, potentially, right? They may have seen you as a bigger pocket, a bigger target, and worth their time to identify as an infringer, right? Also sort of this in the same question you had about how in the world could there be so many patents for similar looking products? Absolutely. I mean, the scope of the rights that a patent holds can be very narrow, right? Very narrow. The longer a claim is, the more narrow and the fewer the rights are. It could well be that someone has a patent for, the certain type of attachment between 2 fabrics of a horse mount, compression head, whatever mask, right? Such narrow detail, the type of attachment and the type of hooking means that these sort of come together for only, equestrian masks, okay? And so you could easily design around that by simply not having an attachment at all or having a different piece of material there. But it's, it's just the case that the inventor, that applicant wanted to proceed with something so specific. Perhaps there's a functionality there that we both don't understand. So there's a lot to unpack with that question. I don't want to spend too much longer on it, but if you have any follow-ups, please do look above and follow up with us via email. All right. There's a couple more minutes left, I should say. And Flavia, you had a question here. Don't know how to eat with chopsticks. The fork has a tendency to slide off. Here comes the swirl fork. Okay, yeah, right on. And so he's on Amazon as well. Good stuff. So I had a couple more questions come in on Alvo. I think we're going to run short on time. So I want to just open up the last minute for live questions, and then we'll go ahead and wrap up for the day. While you guys are wrapping up and coming up with those final questions, I do want to make sure this book gets out there during the session. I wrote this book, Bold Ideas, The Inventor's Guide to Patents, a few years ago. This is still very, very relevant for those that are looking to just get started, understand the basics, nuts and bolts. And so please, if you want to get a copy of this book, take action and schedule a consultation, an advisor session, we call it, with one of my non-attorney advisors to see if patenting is right for you. And if it is, then they will get you in touch with one of our attorneys. Okay, so this is the link to do that right here. Okay, you got the link. Excellent. Well, thank you for the activity, everybody. It's great to see you guys. And really fun interaction. Thank you, Flavio, Mark, and Saksham. Sorry if I'm mispronouncing your name. I apologize. E. Dixon, Chris Holland. You guys are awesome. I appreciate all this. You're very welcome for the time. See you here next week. Share this with anybody else you might know. I mean, think of brothers, uncles, cousins, sisters that are also inventors. Get them here, right? Get them to show up and participate in this fun event. It's a nice, easy, no pressure kind of a Facebook Live where I'm happy to answer any questions that are on their mind. So thanks, everybody. Have a great day. Take care. Go big, go bold.